Okay, I think we're ready. Wow, I did not expect to have this many people that's interested in privacy. Is it because you're all interested in that elusive topic as it pertains to you personally? Or are you interested in how it impacts you with your job? Let's get a hand. So what about you personally? You, okay. What about how it impacts your job? I've heard a lot of people. Okay. Well, today you're gonna probably be a little bit disappointed.
I think this will be better
Okay.
because we're recording it.
Sorry, I like to wander when I talk. Today you might be a little disappointed because you probably thought, ooh, I'm gonna find out how these state privacy laws impact us. There's gonna be some good news and some bad news, so just stay tuned. But my name is Gina, and I am the Chief Privacy Officer for Wichita State University. I am an employee of Wichita State, but I must disclose that what I'm presenting in this presentation is representative of my professional beliefs. It does not necessarily represent what Wichita State does in practice at this current time. And I am not a lawyer, so please do not walk away from this presentation thinking that any of this is legal advice, because I am not a lawyer. So we're going to talk about what is privacy. I want to identify the state privacy laws that are out there, give you some of that information. I'm going to briefly highlight some other regulations that have privacy embedded into them. And then we're going to discuss possible ways to start to dip your toe into the pool of privacy if you don't have a privacy professional at your institution. So to start out with, let's talk about the definition of privacy. You all are probably very familiar with confidentiality. You know that you, as security individuals or ITS individuals, are very concerned about keeping sensitive data confidential. Privacy is actually more than confidentiality. They overlap, but confidentiality doesn't cover all areas of privacy, and privacy doesn't apply to all data that's confidential. If it's non-personal information, privacy doesn't care. So that's one thing to note. Privacy actually has certain liberties predicated or reliant on it. And a couple of those liberties include autonomy and control over self. There's things like bodily privacy. You know, we think about that when we think about that kind of example, or the ability to control how much is revealed about oneself. And so when you think about data and all of the information that is collected in the world today, that's how do we control who has what information about us and who's viewing what information about us. And so those are just two of the main examples. And because of the interesting complexity where we work in this higher ed setting where academic freedom, intellectual freedom is really supported and encouraged, we really have to find and maintain an equitable balance between data use for providing things like information security or university services and activities, with balancing that with civil or individual liberties of that data. So me as a privacy officer, I must view the development of a privacy program not as only as a means for compliance, but as a way to make sure that we are equitable in how we are managing data. And we typically use a risk-based approach that focuses on risk to the individual over maybe risk to the institution like you do in cybersecurity. Now, eventually we're going to talk to the institution about if we don't follow these privacy things, here's how that could impact the individual and then you. But we're really focused on the individual. So, as I said earlier, privacy is the right of an individual to have control over how their data is collected and used. But that has to be balanced with the legitimate needs that the business has to use that data and provide the individual a service. Privacy includes principles such as accuracy and integrity of data, legitimate purpose, transparency around how and when we collect the data, storage usage, providing individuals with options or choice when it comes to how their data is used, when feasible, and then proportional use of data. We're not collecting every piece of data that we ever could in our entire life just because we have a purpose for that, and using data as we are allowed to under the law. And right now, because of the lack of a federal law in our country, there's a lot of gray areas when it comes to that. So let's first talk about personally identifiable information. You all probably have heard this term before, but that is information that can be used to distinguish or trace the identity of an individual. Things like their name, their social security number, biometric records, or even things like someone's date and place of birth or mother's maiden name, if that information is tied to another identifier. And so you're going to hear me talk about PII in the next several slides and see that it is more complex than just defining PII, because in the US, no single law covers all data privacy. How each state agrees to protect the privacy of individuals varies across each state. And so if a breach in the area of data privacy were to occur, and if the public's trust is broken, they love to splash the headlines with the biggest name that they can get about who caused that privacy breach or who caused that data breach. If you all remember several years ago, Target was a breach, you know, that everybody's had in the media how it was all Target's fault. It was actually an HVAC company that was working for Target. So you are only as good as the vendors that you choose to manage your data. As the controller, you have that responsibility to help manage the privacy and security of the data. So if we talk about PII a little bit further, when we talk about securing it, we really look at two different categories of PII. The first is public PII, and this can be things like first and last name, phone number, data that falls under FERPA directory information, or that's printed in phone books, that can be public. And whether data is public can also be context specific. So if you signed your name on a public meeting roster, you could expect that maybe that would be published publicly. If you signed your name on a private meeting roster for a mental health group, you would not expect that to be published somewhere public. So all of those things can impact whether data is considered public. And then we talk about sensitive PII. And the Department of Homeland Security helps us by breaking it down further into two categories of sensitive PII. The first is standalone, and that can be things like a social security number, driver's license number, alien registration number, financial account number. Those by themselves are considered sensitive. Then you look at other pieces of information that maybe by themselves totally aren't sensitive, but if you add any other identifier to them, they can become sensitive. And those are things like medical information, criminal history, and even things like mother's maiden name or the last 4 digits of a social security number. If those are paired with other identifiers, and those can become sensitive. Anybody guess why mother's maiden name would be up there?
Security question.
Yeah, it's the one I always pick too, because it's the easiest to remember. It's probably bad to say. Those who are in security, plug your ears. So let's talk about the state privacy laws. So between the time that I wrote this and now, at least one, if not two, new privacy laws have been passed. So Nebraska was one of those add-ons that happened in between. But as of January, there were 15 states that had passed privacy laws. Florida is highlighted because two different parties of individuals kind of are in disagreement on whether or not Florida is actually a state privacy law because the scope is too narrow. But all of these other states, and I pulled Florida in, have a law passed surrounding privacy. If we look at how fast this is growing, we went from 5 privacy laws at the end of 2022 to 15 by the beginning of 2024. Now we're at 16. As of now, again, there's still no comprehensive federal privacy law, which means that, again, each state gets to determine what happens if there is a breach. And if your university has information from those states, they may come and try to tell you what you need to do in the case of a breach. They may try, doesn't mean they'll be successful. If you think about it, 50 different ways to have to handle a breach is a little daunting compared to one way if there was a federal privacy law that preempted all of these state laws. So that's why you kind of hear me up here going, federal privacy law would be really nice about now. So under these state laws, consumers are afforded certain rights. And these first 4 here on the left, those are ones that these rights all 15 states have said a consumer has. And they're the right to access which information a company holds about them, the right to request deletion of their personal information, portability of their personal information, and the right to opt out of sales. The next section to the right over, most states have provisions giving individuals the right to correct information that's incorrect, the right to opt out of or require opting in to process sensitive data, rights against automated decision-making, and then California is actually the only current state, unless Nebraska threw something in and I just haven't looked at it yet, that has a private right of action. So if there were a breach of somebody's personal data in California, a private individual could come and bring litigation against that company if there were certain harms or whatever shown. So there are certain business obligations when it comes to these state privacy laws. In all 15 states, there's an obligation to provide notice or transparency. This is a very common one. Notice or transparency is one of the main things that you hear about in data privacy because it ties back to that civil liberty. That person understands what you're doing with their data, or you're letting them know, so that they have the decision on whether or not they want to give you their data to get a service from you. Okay, those of you that sit with me on the DMC committee, this is why I'm always asking for, is there a statement that points to the privacy policy, or can we get some wording there? Because this is for sure going to be a requirement moving forward as something that we have to have. There is, a prohibition on discrimination against individuals who want to exercise their rights under these privacy laws. All 15 states have language surrounding individuals who are younger than a certain age, typically that age range somewhere below 13 to 17 years. If you have an individual that's younger than that, they would have to opt in to sensitive data processing. So you would have to be careful about what you're collecting about children. Most states require some sort of risk assessment as part of the law and have a limitation on processing of PII unless there's a legitimate purpose for doing so. So again, it goes back to that idea of you can't just collect all the information you ever wanted just because. You really have to have that legitimate purpose for doing so. Let's talk about exemptions. This is where you're all going to get excited and you're going to cheer. Exemptions occur at either the entity level or the data level. So at the entity level, you'll see references to exemptions for government, nonprofits, and HIPAA or GLBA regulated entities. Higher ed entities are exempted in 75% of the states that have laws right now. Woohoo! And national security associations are exempted in about a quarter of the states. If we switch to the data level and we talk about the specific types of data that are exempt, FERPA data is exempt from all 15 laws. Let me hear it. This should be everybody going, except then we remember, oh, we don't just hold FERPA data, right? At least that's not the case for WSU. So FERPA data is one of those that's generally exempt. HIPAA data is generally exempt because there's already a law that helps with that. GLBA is the Graham-Leach-Bliley Act. I always want to say that wrong. Federal Credit Reporting Act, DPPA is the Driver's Privacy Protection Act. These are all laws that focus on privacy. They're generally exempted, but when I put asterisks by GLBA and DPPA, that means that you're only exempted if you're in compliance with GLBA or DPPA. So if you have a breach and it's found out that you are not in compliance with GLBA or DPPA, then you're no longer exempt from that privacy law. That's fun. And then, oh, this little circle thing is highly sensitive. Human subject research is typically exempt, which is good. De-identified data is typically exempt. The fun part about de-identified data is everybody has a different opinion of what de-identified means. So it differs based upon the regulation and the situation. And then the final two data types that are typically exempt include employee data or commercial business to business data. So again, because there's not a federal privacy law, let's talk about some of the other laws that are out there that have a little bit of privacy embedded within them. All of you are probably aware of HIPAA, which is that healthcare law that you get every time you go to the doctor. They want to show you some 3 to 5 page paper that you don't want to read, and you have to sign that you got it. FERPA, everybody here is hopefully comfortable with FERPA. FERPA education records are different than FERPA treatment records. So if you've never heard the term FERPA treatment record, email me, come see me. I can give you a document on how those are handled slightly different than FERPA education records. GDPR is the General Data Protection Regulation out of the European Union. That's the big privacy law. They're kind of the leaders in regulation when it comes to privacy. COPPA is the Children's Online Privacy Protection Act, which generally applies to website collection of child's data. They're currently doing some revisions to that, and there's some talk about how this could impact educational institutions. So if you ever are seeing stuff about COPPA in the headlines, you might just pay attention. I don't know how this is all going to come out, but CAN-SPAM sets rules for commercial email spamming. Illinois has a biometric Information Privacy Act. And Washington recently passed a My Health, My Data Act relating to individual healthcare data that is stored or collected in Washington state or is from an individual who lives in Washington state. Now, this one, I feel like this is applying to all of those Fitbits, health trackers, all of those things that we do that we don't think of healthcare type data, but really it is data. I mean, this tells me how many calories I burned in a day, tells me what my heart rate is. So this Washington Act is trying to get at all of that healthcare data that's being collected in various ways by individuals that aren't necessarily covered under HIPAA. So now that you know we're living in the gray, where can you as ITS or information security individuals go? The first thing you can do is work with institutional leaders and someone with the area of expertise in privacy in your university or college to define principles that support privacy of the data that your institution will follow. Sometimes those overlap with principles for security. Sometimes those are in direct opposition of security. So it really just depends. Again, that's where the balance needs to come in, because we have to do a job. We have to have data to be able to run a university or a college campus. We have to secure data. So all of those things have to be balanced when it comes to that. A few examples of these principles as related to privacy include lawfulness. So that's handling data as you should by law. So let's say I decided to hire my friend Santi here, and I collect all of his personal information and his social security number, and I decide I need some money, you know, because we all work for state institutions, or most of us do, right? And I decide I'm going to take Santi's social security number and sell it on the black market to get some money. That would be against the law. Can't do that. Data minimization and storage limitation. The big conversation they're having around a federal privacy law right now is about data minimization. Really trying to minimize the data that you collect to only that you need. You have a legitimate purpose, and then only keeping the data you need for as long as you need it, and then try to de-identify it, aggregate it, anonymize it, do something to get rid of the identifiable data. The reason for this is the more we store in terms of data and personally identifiable data, the more risk we have if somebody ransoms our information or gets it and then we don't have access to it, or they share it out there. Maybe it's healthcare information from our clinics and our universities that we don't want out there, and they take it and they make it where we can't operate, or they share it where we don't want it shared. So the less you have, the less risk you have. Purposeful limitations, only using the data you collect for the purpose it was collected. And this is hard because somebody has either had to document why it was collected or remember. And I don't know how good either of those things are happening at this point as we're trying just to tread water, right? A good example of purposeful limitations, I pull, because I used to be a clinic director in a speech language hearing clinic. Sometimes we take pictures of our patient's face because we want to look at the face symmetry, and we use that for treatment purposes. It would not be appropriate for me to then just take that picture and plaster it on a marketing billboard for WSU if we do not have authorization to do that, and we didn't say that that's what we were going to do with that. So that is what a purposeful limitation is. And then data accuracy and integrity, those come down to obviously making sure the data you have maintains accurate in the form that you collected it, that it's accessible when you need it. Because if you're a healthcare institution, you have patients coming in the door and you can't access your medical record system, that's a problem, because you rely on that information in that moment on a daily basis to treat your patients. A lot of your information is reliant on what you have in that medical record system. And so those are principles that come from GDPR, that General Data Protection Regulation out of the European Union. I also want to remind you not to forget about those individual autonomy things that I talked about. And that includes providing option and choice. So that's where you see like those cookie banners and you say, do you want to allow cookies on this website? And yes, no, yes, no. So you can offer option and choice to the individual interacting with your websites by doing something like that. And then transparency is those notices or privacy information pages that let individuals know how you collect data and what you do with it. So after you have thought about all of that, you want to start to utilize those principles that you feel are important for data privacy to help drive decisions surrounding data sharing, access, storage, and use in new products or activities. Privacy is by design is what we call this, where you bring privacy in at the beginning of a project, and then you don't have to fix it later because you realize, oh, we created this project and it doesn't meet privacy standards, and now we have to recreate it. A great example of how we do this at WSU is in our data management committee. This committee was formed with the idea of vetting vendors before we just hand them bunches of our data. And we look at what is the security of their system? Do we already have another system that does this that we don't need to spend money on again? What does the privacy of the system look like, or what are their privacy principles? Is it accessible? So those are just some of the things we look at. And so if we are looking at that before we even onboard that vendor, then we can go about, like I said, sometimes I'll meet with the person who wants that system if it's approved. And I'll work with them to either link to a privacy policy on that system, or okay, I'm spinning it the wrong way. I'll work with them to either get wording out there on that system or link up to a privacy policy from that system. So it's very apparent, this is what this system is going to be collecting about you if you choose to use it. So, and especially if we select systems that we don't really give our students a choice to use, we need to be the advocate for them, making sure that their individual liberties are still being thought about. The other thing you can do is start to document and understand how and what type of PII is flowing through your applications. I need to follow this up with a huge disclaimer. This is no easy feat. It's a hard process that typically involves multiple stakeholders from different areas of the university. And it needs to be, once you start collecting it, that needs to be kept up to date. So because of this, you should probably consider partnering with others in your university on this task. Or you can start your own documentation in areas which are already functional. I'm going to give you a couple of examples. Another one goes back to that DMC committee. I was working with Brett from that committee, and I heard him say something about, well, I'll have the information of what we transfer from them to that vendor when we're done, you know? And I was like, ooh, Brett knows all the answers, because when people come to you with their ideas, they never know exactly what data is going to be collected. And they usually give us a list, but how often is that list accurate?
Yeah.
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 So I thought, man, Brett has the answers. I can go to him and I can start collecting that and documenting that for my privacy. Well, he heard that I was interested in that. And just by chance, ITS was already working on an application information finding where they were trying to collect information about all the applications used in the university. And they are allowing me to add a couple of questions about PII to that investigation so that that information can start be collected for me. So find those people that can help you do what you need to do. Okay. Now my spinning is not working the way it should. Another option is there are frameworks, crosswalks, guidelines out there that outline privacy compliance very clearly. I would not recommend this as a place to start. You are just going to overwhelm yourselves. You're going to tick off a bunch of people and you are going to burn out and be done with your job. But I think it's helpful to look at them and know what they're asking for in general so that you can strategically plan how you might attack creating a better privacy environment at your university. So those are all out there. You can bet if we do ever get a federal privacy law passed, somebody will probably make up a nice little thing that we can follow. So those are also there as well. So just to reiterate my key takeaways, privacy laws apply to personally identifiable information and can be very complex. It's not just about meeting a compliance requirement. It's the balance between the right of the individuals surrounding their personal data with the legitimate business needs to be able to provide that same individualist service. And when I mean service, I mean education, I mean healthcare, I mean, you know, whatever they're obtaining from you. The last takeaway should be that it really is based upon, and you're gonna hate me, so don't start booing, your individual university situation. So what I say today may not apply directly to your university. We all may be in different areas of our privacy journey at each university. So if you're a public versus a private institution, if you're for-profit versus nonprofit, or just based upon the different types of data that you hold, some of these laws or all of these laws or none of these laws may apply to you. So it's probably best to consult someone with privacy or legal expertise to help guide you in a strategic development plan for how you're going to improve privacy and kind of get ready for a looming federal privacy law. So here are my resources. Are there any questions? Yes.
Coming at this from a client services standpoint, dealing with our faculty, staff, and users, do you have any comments, suggestions on how institutions or especially IT departments can deal with the situation of people generate PII or protected information, but it's not stored, especially in those old situations, say our student information system or Microsoft 365, where we can have automated pay. Because there's how many hundreds of applications out there, people store data on their flash drives, external hard drives, local hard drives. So how do we deal with that faculty and staff who are not privacy experts? And then also, what do IT departments and especially the client services people do when they come across those situations?
I would say definitely work with your privacy person. I would love to talk to you about this more, but generally what we're doing and what we're saying in our HIPAA covered entities for sure is USBs need to go away, period. If we can find a way to make those go away, great. If we can't, let's encrypt them. Let's make sure they're encrypted. That doesn't mean that every person that's ever used a USB is going to come to us, right? You're always going to have those outliers, but we've provided education and training. We've provided an ITS help desk who could help get that out there. You guys may get calls from individuals you're realizing it's happening, your communication with myself, the cybersecurity office. We can help educate those individuals as to, hey, this is not the best device to store sensitive data on, and here's why. And then we tell them our story about a guy from Lifespan Health Systems who lost a laptop, and that little lost laptop ended up costing $3 to $4 million for that health system. So it really is a culture change more than anything. Eventually you may all have systems that can block USB use and stuff like that, but you're also going to have a lot of angry people. So I feel like it's that culture change that has to happen for people to understand the why behind it. Does that answer your question? Okay. Reach out to me when we get back to the university. I'd love to work with you on that.
So I have 3 questions. Yeah, the first one, there's time.
Okay.
So first question is, are you familiar with higher education? Is that effective for just as a generic evaluation with it, or is there a better way?
They are actually working on, EduCog is working on a privacy focus neck then.
Yeah, they have a head pat. I've looked at both. It's very comprehensive. I have something called a privacy impact assessment that I do. I think in a perfect world, if we could somehow get vendors to fill those out and then store those collectively, like I asked EduCause, is there a way you could collect those from vendors and put them on a list? And then when we work with a vendor, you know, and I think they're working on that. They have a website, but it comes down to some of the vendors that you really need don't necessarily want to fill it out. So again, that comes back to a cultural shift. as soon as we kind of shift as a culture to this idea of data privacy and security is important and everybody's on board, it's gonna be a lot easier for us to require big lifts like that. But you've got some vendors that sometimes see us as small potatoes. And they're kind of like, yeah, we don't have time to fill out that survey. You can go on your way. So we have operationalized our own internal and external surveys to gather some of the same kind of information. But it is not necessarily as comprehensive as, but I think it's a good tool to look at. And maybe you kind of mold it a little bit to fit what you need for now, and then it could evolve into something bigger. Okay, can I answer his and then I'll come back?
I just wanted to add to this discussion. So I'm with the University of Kansas. I
Mhm.
just recently heard from our IT leadership. They bought a product called Smart Suite,
Okay,
and it is some kind of like portal, like software as a service. They're gonna upload all the HECFATs and all the information we get from vendors at KU into that, and then IT, procurement, and security, privacy, whoever will have access to the look. So any vendor that's under contract will be.
yeah,
So
that
I
would be
think that's
great.
a good start.
Mhm.
I
Yeah,
mean, we're just now like even just signed a contract with that vendor, so it's not.
Yeah. Yeah.
It's not as if
I would bet that bigger entities like EDUCAUSE are gonna see that we all need help with areas like this. And they're gonna help us, convince people that this is a good thing to
They
do.
have a list of
Yeah.
GOCs.
Yeah. Yeah.
Just like.
Yeah. And I looked at the list the other day, I was like, man, none of these are the top ones that we maybe use. So, yeah, I think that they're trying. I just was at EDUCAUSE and actually watched you speak in the final one. So, do you have a quick question? And then I'll go back to him.
Sounds good. Yes, what about dealing with politics in between departments as far as privacy? We.
Now, this is getting exciting.
That is an issue that I feel like we are running into, and it sounds like, maybe other people are as well.
Yeah, you have some people that are on this side and you have some of the people that are way over here, right? Yeah, and then most of us are here. Yeah.
Do you have any advice on this?
I feel like my approach, and I have only been the privacy officer at Wichita State for almost 2 years in August, I need to understand the culture that I'm working in. I need to meet the people that I'm working with on a daily basis. They need to understand my role and why privacy is important. So before I start to task list them with things, I honestly started out in our HIPAA covered entities first. That's where I spent the majority of my time the last year and a half, and I'm just starting to shift over into beyond HIPAA privacy world. And so it's my plan to meet with each of the data stewards, really kind of say, okay, here, I know you've heard me, you see me on DMC, but you probably still don't really understand what I do, let's be honest. And really get them to understand what I do, but also listen to them and say, what is it from a privacy standpoint you worry about? Or is there anything that I can assist you with from your standpoint? If I go to meet with HR, hopefully soon, you can bet I'm going to be looking up their employment laws to see if I can pull privacy little tidbits out of those that I could be helpful with. But really I think it starts with really trying to get to know your environment, know who you're working with, understand it, and start to build relationships so that when I do have a hard ask, I can be able to know that it's not just me showing up cold one day and trying to get someone to buy in. Did that answer your question or not? Are you talking more about two departments fighting?
So from an IT perspective, as far as what we have, often we have departments that keep saying, new shiny toy, we want this. And for example, we had to reach out to a vendor, when we do a vendor risk assessment on them. We actually had to go all the way up to the vendor's president to get someone out. But I do know, like, for example, marketing loves to collect data. They love that data.
Yeah,
Makes sense. They
Yeah.
send the graphics.
yes. So that is definitely That is definitely the challenging part, but then it's you also being able to understand their perspective. And as my good CISO tells me, I am advisement. So at the end of the day, I get to advise on the concerns, I get to advise on the risk, but it's not my final decision whether that department gets the shiny new toy. That's gonna be somebody like the provost or the president. And
I'm gonna
Brett,
do a shameless
Yeah.
plug, because I know we're almost out of time. Gina has talked about data management committee and some of that. My presentation tomorrow morning at 9 o'clock in this room is going to be more broad about what that data management committee looks like and how we partnered with Gina and those groups and the impact that's had on, I think, the answer to your question.
Yeah.
On when people come asking for data, what do my developers tell them? And it's actually helped alleviate some of that pressure, so.
Yeah.
Are you Brett?
Yes, I'm Brett. They will tie in together quite well. I had no idea what this is about. This was great.
thank you. Okay, I'm gonna go to you, and then if anybody wants to, I can take time to stay after if you have any questions, so.
So this builds off of kind of what you were saying, you were just saying, kind of what we talked about. Also some of our collective experiences here at KU. So you said data management, and part of our kind of challenge at KU is trying to find the most efficient and effective way of going through and evaluating vendors. So part of that is, it's not just a security, but people see it as so, and we catch flack because the process is slow, but we have a lot of different stakeholders. So my question is, and it's an open question, what is the best combination of stakeholders that should be a part of this evaluation process?
Well, at WSU, and please chime in, Ken and Brett, we have the chief data officer, myself, the chief privacy officer, chief information security officer, and the chief information officer. It's kind of this data governance or the C part of that. And then we have a group of data stewards. We have individuals who represent accessibility. Obviously, privacy and security are covered. Again, we have the information officer. You're usually asking questions about, do we already have this vendor solution? Can we add, whatever this is gonna take onto the list of duties that's gonna need to happen just to get this up and running? Who else am I forgetting?
Finance.
Finance is on there, somebody from finance, somebody from HR, right?
Yeah. We have all the key data custodians and data owners. And
Registrar.
yeah, Gina alluded to the fact that, it's nice when you're dealing with seasoned vendors, is the way I'll describe them. It's like, here's the minimum data you need to give us. Here's the optional data. You guys can make the decision. The ones that always throw the red flag that I'll talk about tomorrow that I love, or, well, what data do you want it to have?
Or when I ask for their privacy policy, which is kind of a standard, if you even have any kind of website, like that's something you have to have. Well, I don't have one yet. No, yeah, so sounds like you need to go to his talk tomorrow. Because I would say that's my best answer for you, because I think he's gonna have a lot of good information. All right, well, thank you all.
Thank you.